Not tomorrow.
That's okay.
Yeah, it's nice to see.
I don't know what season.
That one season.
Original spring.
It did kind of shade the outer
Mud
edges of my
season.
face.
Okay, Mr. Malone's, are you both on the phone?
Yes, we are. Good afternoon, everyone.
Good afternoon. Before we go on the record, does anybody have anything they need to discuss before we go on the record? Okay. Good afternoon.
Nice.
We're here today for oral argument in case number 19-3031 PET, the petition of Otter Creek Solar LLC, requesting non-substantial change determinations or in the alternative amendments to the certificates of public good issued to the Otter Creek 1 and Otter Creek 2 solar projects in Rutland, Vermont, in case numbers 8797 and 8798. My name is Anthony Roisman. I'm the chair of the Public Utility Commission. With me today are Commissioners Margaret Cheney and Sarah Hoffman, and also our General Counsel Kyle Landis-Marinello. I'd like to take appearances, please, and we'll start with you, Mr. Malone, please.
Tom Melone from Allco Renewable Energy, and Michael Melone is also on the phone with me.
Okay, and which of the Malones will be arguing today?
It will be Tom Melone.
Okay, thank you. And the department?
Daniel Burke on behalf of the department.
And Agency of Natural Resources?
Don Einhorn on behalf of the agency.
Okay. And we're here because Otter Creek Solar requested oral argument on the hearing officer's proposal for decision. We're scheduled for up to 1 hour of argument this afternoon, although the parties need not utilize the full allotted time. Otter Creek, you'll start us off and have a maximum of 30 minutes to make your argument, including any time you decide to reserve for rebuttal. Do you wish to reserve any time for rebuttal?
Yes, we would, Mr. Chairman. We'd like to reserve 10 minutes for rebuttal.
Okay. All right. And the Department of Public Service and the Agency of Natural Resources, you will be able to present an oral argument for a total of 30 minutes. Have you decided how you wish to divide that 30 minutes?
We have not, but I don't have any prepared remarks, but I would like to reserve time just to respond to any arguments that the petitioners may make or respond to any questions that the commission may have of the department.
Okay.
Same position for the agency.
All right. Good. Mr. Malone, you may start.
Thank you, Mr. Chairman and other commissioners. Good afternoon. Thank you for the opportunity to address you today. I'm going to make this short because I think what's left here is fairly narrow, as described in the department's most recent comments. The remaining two issues, unless the commission sees something else, are the alleged violation of Rule 5.408, and secondly, the single plant analysis. On Rule 5.408, as we've argued in our written filings, we do not think there is a violation for the following reasons. 5.408 only addresses or talks in terms of construction of generation. As the commission's already decided, as we've argued, what was involved here was a temporary road for site clearing only, not construction. So first, we think that the rule doesn't even apply because 408 only talks of construction. Second, 5.408 talks about amendments to a CPG. The commission's already decided that the CPG was not violated by that temporary use of a temporary road for site clearing. So that there would seem logical that there's no amendment needed to a CPG.
So do you think
The
that,
CP,
Mr. Malone, do you then think that 5.408 and a CPG violation are exactly the same thing? That they're equal?
well, no, I don't think that CPG violation and Rule 5.408 are the same thing. This 5.408 is one only deals with amendments of the CPG. So, you know, a CPG violation can occur under its current terms, you know, without regard to any amendment that might be necessary. And 508 deals with construction, and the CPG itself could deal in theory with more than just construction. And 5.408 only deals with what's referred to as a substantial change. And the substantial change part is also one of the reasons we think that it's pretty clear there's no violation here. It's because the evidence which we've introduced, which is basically not contradicted by any other evidence, is that the temporary use for the site clearing had no potential for any significant impact. I mean, actually, the evidence says there's no potential for any impact, not just no significant impact with respect to any of the criteria under 248. You know, and indeed, as we mentioned in a more recent filing, you know, the level of traffic here for site clearing is far less than what would be undertaken in conjunction with decommissioning of a project. And that decommissioning was already approved from an access off Coal River Road. So we don't see any basis on which there could be a violation here.
So substantial change would only be judged after the fact instead of prior to making the change and doing the work?
I think a substantial change could be ruled on before, could be ruled on afterward. The question to me is, the way the rule reads, it's a factual question as to whether whatever the change was or is proposed fits within the potential for significant impact under 248. And we've cited in a more recent filing, commission decision in connection with the analogous rule under 248A, where the commission made clear that after the fact changes were not required to be noticed of the commission. And, you know, again, I don't see any difference between that situation and here. And there, the changes that were felt to be not required to be noticed were redesign of tower foundation, replacement of temporary facility, repositioning of equipment, and installation of an armored on-the-ground electrical service cable and transformer. Here, we're just talking about some gravel for temporary access.
So, Mr. Melone, I want to make sure I understand your position on that with regard to the answer that you gave to Commissioner Hoffman. If instead of the number of trucks per day that actually used this access, it had been 50 trucks a day that had used this access, would you believe that that would also constitute no potential for significant impact?
Again, I think it is a factual question that, say in our case, there would be expert testimony on whether the increase from, say, whatever it was, 5 or 6 to 10 times that, had the potential for significant impact. I don't think that the rule says, well, gee, you know, if 5 is okay, experts would say that 10 times that would not, did not have a potential for significant impact. It's really up to the experts, I guess, to say at what point the factual threshold for a substantial change that has potential for significant impact is reached.
So if I
Because
understand.
otherwise, we're just guessing.
All right, so if I understand your position, you're saying that instead of advising the commission in advance as to how much a particular change was going to effectuate the environment, that you would make the change, do whatever it is you wanted to do, and then if subsequently it was raised, at that point for the first time, the commission would be advised as to whether or not you, the petitioner, felt that it was causing the potential for significant impact, rather than upfront saying, here's what we want to do, we don't think this is a substantial impact, and getting the okay or the denial before the action was taken. Am I understanding what your position is on that?
That's correct, Mr. Chairman.
Okay, thank you.
So unless the commission has any other questions of me on the 5.408 issue, that's all I have to say on the 5.408 issue.
Mr. Melone, this is Kyle Danis-Ranella. So you do agree that this was a change to the approved proposal, right?
We have stated, yes, it is a change to the testimony that was there. I mean, it's impossible for me to tell whether and to what extent that was a significant factor in the commission's decision, but we have stated that it's clearly different. Like any change, it's different from the way it was described in the testimony.
Okay, you can go on to your next point, Mr. Melone, if you wish.
Okay, thank you, Mr. Chairman. On the single plant analysis, the commission's fairly well aware. We probably have the most experience on the developer side in that connection. I just do not see, like we've said in the filings, that there's any basis to say that the temporary use of the temporary driveway that would be removed and not part of the project or the facility, and possibly make what otherwise would be two plants a single plant.
You would agree, though, that the driveway is infrastructure, correct?
No.
You don't believe a driveway is infrastructure?
I don't, because it's removed. It's gone.
Okay, so it's not that it's not infrastructure, it's that your definition of infrastructure is it must be something that's permanent.
Yes, but you have to judge the determination of whether a facility is, or say what the size of a plant is, and whether two facilities constitute one plant based upon what they look like constructed. I mean, that's the clear import. I mean, the whole reason for, I guess I wouldn't agree that a driveway, even if it were permanent, is quote infrastructure. I would agree that it would be a road as defined in the statute, essentially, but not infrastructure. I mean, I think the fact that the statute talks about roads means that that would be classified again, it's got to be permanent.
So,
Gotta
Mr.
be,
Malone, how do you define infrastructure?
I mean, it could be supports, it could be common electrical wires before the point of interconnection. I agree the whole series of roads could, could be considered infrastructure.
Did you say, I'm sorry, did you say a whole series of roads could be infrastructure? I just
Yeah,
couldn't hear you.
Yeah. Now, let's get back to the statute itself. So, let's see.
Well, I'm gonna turn you to the definition of plant, where it says infrastructure such as roads.
Right, okay, yes, that's what I'm looking at now, that's why I haven't been silent here, I was looking up the actual statute. Yes, I think that's right, the roads, roads would have to be considered infrastructure because they're not equipment and control facilities, I guess would have to be considered equipment considered, not infrastructure.
So then, back to my question, is it your view that these two access roads are not roads within the definition of shared infrastructure because they're temporary? Is that the distinction that you would like us to focus on?
Yes, that's right, Mr. Chairman.
Okay, and if you were to put them in and they were going to be there for the duration of the project, but then removed when the project was over, as it frequently is provided for in the decommissioning provision, would you then say it was a temporary or not temporary?
Well, I'd say it's not temporary because it's permanent as to the operation of the facility.
So if it's there for the duration of the facility, it's not temporary. If it's there for the duration of the construction of the facility, is it temporary or not temporary?
I'd say it's not temporary if it's there for the duration of the operation of the facility.
But what if it's there for the construction of the facility? Is it temporary and then removed?
Yes, it's temporary. Because a facility, the statute talks in terms of plant being an independent technical facility that generates electricity from renewable energy. I mean, to me, there's no other way to look at that as anything other than focusing on once the plant itself is in operation and, quote, generates electricity from renewable energy.
So the focus of your argument on this piece of the single plant analysis is that these two access roads were temporary and therefore didn't meet the statutory definition of being a road, correct?
That's correct.
But I take it you don't dispute the fact that these temporary access roads were shared by the two facilities, is that correct?
That's correct.
Okay.
Yeah, I don't dispute that.
Okay, good, thank you.
So that is our view on the construction versus site clearing as it relates to the temporary road. Of course, the statute itself even if this were, quote, a shared road and shared infrastructure, there are two other aspects that are plainly not present. There's no common equipment between the projects, and there's no common connections to the electric grid. That's even putting aside whether these could meet the definition of project that's in the statute now. And I would, on that one point about, I view that it is a fully constructed and operational plant that needs to be looked at. The earlier version of the statute expressly referred to newly constructed. When the legislature added a sentence that dealt with the term project and allowed three factors to be considered, they took that out in terms of newly. That there's no indication that it was intended to do anything other than just remove the concept of newly constructed rather than constructed.
And do you have any view that you'd like to share with us on what you think is the underlying purpose of the single plant provision in the statute?
Yes. When it's basically designed to address wind plants, the way a wind farm is typically constructed. I guess there aren't many in Vermont, but one of the ones I guess GMP owns somewhere has multiple wind turbines. Wind projects are all connected with a whole series of roads. They do have a single interconnection, usually. Each turbine, in theory, though, is an independent technical facility. It's, in theory, it's an independent technical facility under the tax credit rules, under the Internal Revenue Code. So I think this definition plan was intended to make sure that you couldn't have a series of 2.2 megawatt turbines as part of one facility and fit under the standard offer project.
And why would you think that would be different for solar plants under the standard offer program?
Why would I, well,
You're telling us that you think it was designed for wind, but why wouldn't the same
Right.
consideration also be for solar projects?
well, I think the question the chairman posed was, do I have any view as to why the legislature put that in there? And I think that's why. I mean, they specifically mentioned such as wind turbines. I mean, they didn't mention solar facilities. With the same language applied, I mean, they make obviously no distinction by carving out solar. I think that's the argument that's being made, but in terms of what was intended, why this is in there, I think that was why it was, and that's why they specifically mentioned wind turbines, because when they wrote that sentence, it makes it clear that they had wind turbines, a wind plant in mind.
Well,
Uses common equipment, common infrastructure.
But Mr. Melone, if that had been their intention, they wouldn't have used the words such as, would they? They just would have said wind turbines. The such as is using that is illustrative of something that at least on its face looks like they were thinking about things other than just wind turbines. Isn't that true?
I mean, that's certainly the argument, I guess, that's being made. Do I think that they had that in mind? No. I mean, I've listened to all the testimony on plant statute, looked at all the handouts that were given to the various committees, the finance committee, the other committees on this, and not one really talks much about this. But they do say group of facilities such as wind turbines, and such as generally means not, it doesn't limit the access, but I think that's what, that's why this was drafted the way it was or put in there. Now, clearly the statute was amended after our case in 2014 to add the 3 factors for the commission to consider. So I think that's probably, leans towards saying, well, yeah, obviously, whether the legislature intended it earlier to only apply to wind turbines, since they were reacting to the 2014 decision, then this new sentence that was enacted supports the idea that it should be applied equally to all facilities.
Mr. Malone?
Which is what,
I'm sorry, Mr. Malone?
which we have not disputed here. Right? We have not disputed that.
Mr. Malone, your 20 minutes are up.
Okay.
You can go on and take your part of your reserve time, or you can stop now.
I'll stop now, Mr. Chairman.
Okay. Mr. Burke?
Thank you, Mr. Chairman. There are just a couple points that Mr. Melone made that I'd like to respond to. He made an argument about Rule 5.408, and this is an argument that I don't recall seeing in the briefing, maybe it was there, that 5.408 is limited to construction, similar to the decision you all had on the CPG violation docket. The actual language for 5.408 reads an amendment to a certificate of public good for construction of generation or transmission facilities issued under 30 VSA Section 248 shall be required for a substantial change in the approved proposal. And substantial change language in that sentence refers back to the approved proposal, which is very different than the CPG language that you were looking at in the other proceeding, which expressly used the word construction. And that decision was not in any way, shape, or form a vindication of what the developer had done in the case there. It was simply, I think, the hearing officer's proposal used the language of scrivener's error in terms of how the condition was drafted. So I think looking at Rule 5.408 is very, very different than the analysis that the commission conducted in that case. And I think really that's the only point that I wanted to respond to that Mr. Malone made. If you have any questions of the department, I am here and available to answer them.
Mr. Einhorn?
Just a brief comment. Seems like the agency is thinking along the same lines as the department today. I too thought I heard a proposition that Rule 5.408 is limited to construction. I certainly don't read it that way. I read it the same way Mr. Burke reads it. And one of the phrases I focus on is it talks about a substantial change in the approved proposal, the proposal. And so if you look at Rule 5.402 C1, which are the filing contents under the filing requirements for a proposal in 248, subsection C talks about you have to file a site plan, and the site plan talks about identifying existing topography and changes in grading, talks about tree lines, indicating those sorts of things. So it seems to me that the proposal and everything that has to be in the proposal is not limited to construction.
All right, Mr. Einhorn, Mr. Malone argued that the change that they were making, namely the putting in of the access from Cold River Road, from where they had originally indicated in their proposal it was going to go, doesn't involve a potential for any substantial impact on the environment. Does the agency have any view on whether or not that change did have the potential for an impact?
I believe what we indicated in our brief was that while it had the potential to have an impact on the natural environment, the potential was not for a significant impact. And the reason for that is because the natural resource assessment that was done by petitioner's consultant at the inception, it covered, or it included, I should say, those areas that include this driveway that wasn't originally proposed. So that was assessed for the presence of natural resources. The agency was out there, also looked at the project site, and our conclusion was that there were no apparent natural resources in that area, so there was not potential for a significant impact. But that's a distinction between a potential for an impact. And so because of that, and because this is actually, I think, something that's materially different, is that even though it's perhaps not a substantial change, it is a change that is material and I believe would warrant the need for that change to be memorialized if it were to go through as part of the 248 proceedings and treated as a material change by the commission, which I think is somewhat distinct from a substantial change.
Could I ask a clarifying question? You said that there was no potential for significant impact in that area. What did you mean by in that area? Did you include the temporary access road area that was actually used when you said
Yes,
in that area?
yes, we looked at both. So and the natural resource assessments that were done for the two projects included both the areas that were to be disturbed in the initial proposal, and then the areas that one ended up being disturbed by the expansion. I think it was 1,600 square feet of clearing in addition for the temporary access, and then the proposed alternate access to Otter Creek 1. Those areas were examined in the underlying initial petition, and they didn't have, say, rare plants or wetlands that existed in other areas. So for that reason, while clearing trees is certainly an impact to the natural environment, our view is that they weren't, say, clearing them in a wetland, or there wasn't a rare plant there, or wasn't an irreplaceable natural area, or something that would kick it up to the level of a significant impact.
The agency's analysis was not looking at traffic impacts, though, correct?
That's correct. Our analysis, and I think I stated this in our brief, was limited just to the effect on the natural environment.
And Mr. Melone also argued that it was an acceptable procedure when a change like this was to be made in a proposal to go ahead and make the change and then look back and see whether or not that change was sufficiently material to require a substantial change amendment versus no substantial change amendment. And rather than, before the change was made, coming to the commission and saying, this is what we'd like to change our proposal, and we don't think it's going to be substantial, and here's why. Does the department, does the agency have a view as to which of those two is the preferable way to look at these?
I think looking at it after the fact is potentially highly problematic, because what if there were in fact a significant impact, now what happens? So the whole purpose, I think, of this rule is to say, if you're going to make a change, we need to look at this change first and see if it has a potential for a significant impact. If it does, then you need to file for a CPG amendment, and there's more process involved in that, and we may need to put in our instance, testimony addressing here's the impact, and this would effectively result in an undue adverse impact, which is what we look at in the underlying action.
Thank you.
Mr. Chairman, may I respond to that question as well?
Sure.
I think the result of the situation you lay out is exactly what happened here. Any developer can do that. They just carry the risk that if there's a complaint filed against them where the department or the commission initiates an investigation, they're subject to penalty or CPG revocation, which is what's potentially happening to the developer here. And I think some parties tend to be very, very risk averse and will file non-substantial change determination requests for very, very minor changes. I know that happens in 248A quite often with some of the carriers, but that's ultimately, that's for a petitioner to determine how much risk they're willing to take on from our perspective.
Anything else, Mr. Reinhold?
No, thank you.
All right, Mr. Melone, you've got, I'll give you the full 10 minutes because we kind of took up a little of your time with questions, so you've got 10 minutes.
Thank you, Mr. Chairman. What I basically hear from the proposed decision and the Agency for Natural Resources right now is that any change is required to be notified to the Commission. One, the rule doesn't say that. Clearly does not require notice of any kind. The Commission in that earlier case that I cited under 248A specifically says that's the case, no notice is required. I think from a practical standpoint, if the Commission tried to amend its rule under the Vermont Administrative Procedure Act to require notices for any change, and then create more process to determine, one, whether it has the potential for significant impact, there would rightfully be a lot of pushback from everybody, because there are, in any construction project, whether it's a house, building, solar project, anything, there are always changes. I mean, when the CPG is filed, or when a petition for the CPG is filed, the developer may anticipate using 350 watt modules because that's the technology that's available. By the time the proceeding is over and the order equipment, those may not be available anymore for whatever reason, either a change in technology, price, or other reasons. Developer might switch the racking company, but might keep the same style of racking. When the people are out in the field, they may discover, oh, gee, there are rocks in the ground here that we didn't anticipate, so we can't put the racking exactly where we thought we would. We have to put it, a few feet down or 10 feet down, or this row has to get a little longer, even if it's all within the area that was assessed. I mean, it's just basically on and on changes that occur to any project in the field. And what the agency here is saying, and the proposed decision is saying is, well, gee, everything has to be noticed. And if that's the Commission's conclusion, and I think that's not correct, that would not be correct. They can't just act on complaint. The court just made that clear. That's clearly selective enforcement. So the department or the agency have to survey every project that's been built already, ask what changes were made from the approved plans. Because only in that scenario that selective enforcement does not occur. But in any event, I think that the rule itself does not require notice. The Commission has said it doesn't require notice in the companion 248A rule. And like the department just said, it's really a question of risk. The developer thinks, well, maybe this change has a significant impact. Maybe we should notify, or maybe we should notify and ask for an amendment, even if they don't think it is a substantial change. But here, for all the reasons we've given, we didn't see that there was any potential for, again, significant impact under any of the criteria in 248.
Wouldn't you say, Mr. Malone, though, that the risk can be different? It can be, oh, we're going to face a monetary penalty, so we're going to do this anyway, because we don't think it's just going to be a substantial change. But when you're talking about environmental impacts, aren't you in danger of having the harm happen that cannot be reversed by any kind of monetary penalty?
Yeah, I mean, I think there certainly could be situations where there's some environmental impact, like I don't know, the tearing down of a tree that might be protected. I mean, I don't think that is a rule in Vermont, but certainly in places like California, you're not allowed to take down certain trees for any reason. So if you do it intentionally or accidentally, penalty wouldn't put that tree back, but certainly you could potentially grow another one in its place, or 5 more. That's why there are mitigation rules. So depending on the environmental impact. I think even the agency, and they can comment on this, but certainly other environmental agencies in different states allow irreversible impacts if there's some mitigation, either 1-to-1, 2-to-1, or 3-to-1. So sometimes developers can eliminate a wetland someplace, but then they got to create a wetland, one that's much bigger somewhere else. So I think the penalty system is designed to, while it can't physically put back whatever maybe was taken down, at least not at that point, it might be possible for either the penalty or some other direction, injunctive relief, to put it back the way it was eventually.
Mr. Melone, you've got about 4 minutes left.
Yeah, that concludes my remarks, Mr. Chairman, unless anybody else has any comments or questions of me.
All right, well, thank you very much, both Malones. Thank you for being on the phone and for presenting your argument, and to counsel for the agency and the department. Thank you. We will take this under advisement and hopefully have something out in the very near future. We are adjourned.
Thank you.